and held her on the couch and proceeded to strangle her.
She has a mental illness and has been in and out of rehab multiple.
Before this hearing even begins, the allegations are already explosive. Prosecutors say a night of drinking spiraled into a violent domestic assault, a shattered phone, a gun safe opened in the heat of an argument, and a woman allegedly strangled multiple times while a child slept in the home. But here's the twist. The defendant was originally given a personal recognizance bond, meaning no cash required for release. Now the prosecution is calling that decision an abuse of discretion. So the question becomes, did the court go too easy the first time? Or is this an overreach fueled by emotion and past mistakes? Let's break down exactly what happens inside this courtroom.
Court does call the case of People versus Gary Carmichael.
And then on behalf of people,
Assistant Public Defender Natalie Pate with and on behalf of Mr. Carmichael, who stands to my right. Please state your name for the record, sir.
Gary Walter Carmichael.
Oh, excuse me one moment. I don't have the motion.
Grab it for you.
All right. This is the people's motion. They're just bringing the paperwork. This is the people's emergency motion regarding bond.
yes, Your
So
Honor.
go ahead.
Just to start, the defendant was arraigned on January 3rd and was given a PR bond with the GPS tether no alcohol tether. By over for $25,000 surety bond, a GPS tether, and an alcohol tether. The events in this case stem from an incident between the defendant and his partner and the mother of their 2-year-old child. On that day, the defendant had been drinking. And the victim described that he consumed a pint of liquor and 2 tall alcoholic beverages before this incident. And initially, they had a verbal dispute that escalated into physical violence. And in that, the defendant originally took the victim's phone and threw it against a wall. He then proceeded to go to his gun safe and start digging around in the gun safe. Then he returned to the victim, charged at her while she was on the couch, and held her on the couch and proceeded to strangle her. The victim described the defendant trying to strangle her 4 times and ultimately punching her in the face. She also reported to officers that there had been multiple incidents that involved domestic violence that she never reported, including an incident where he picked her up by the throat and threw her against a wall. During this incident, she was pregnant at the time. I also concerns officers noticed.
Let's pause right here, because this is where the prosecution sharpens its argument. They're not just focusing on the alleged strangulation. They're building a pattern. Alcohol consumption before the incident. Prior convictions involving drinking. A gun safe being opened during a domestic dispute. And most critically, visible injuries consistent with strangulation. In bond hearings, judges aren't deciding guilt. They're evaluating risk. Risk to the victim. Risk to the community. Risk that the defendant might reoffend. The prosecution is essentially saying, this isn't just one bad night. This is escalation. And when you add in a child asleep in the house, that dramatically raises the stakes. So ask yourself, is supervision enough here, or does the court need financial skin in the game to ensure compliance?
Injuries consistent with their statements, including strangulation marks, a busted lip, and blood on her shirt, as well as furniture being out of place in the residence, table being turned over. At the time of this assault as well, there was a child asleep in the home. So I have concerns for her safety, the community safety, and I believe that the original bond as set was an abuse of discretion, given that he, in his previous criminal history, does have convictions related to drinking. So I would have concerns that he was not given an alcohol tether. I would ask that for the court to set his bond at our $25,000 surety bond with the GPS tether as well as an alcohol tether, given the seriousness of this case and the charges the defendant is facing.
Ms. Payne.
Thank you, Your Honor. Ultimately, we are asking that the court keep the monetary amount the same, being a PR bond. I do want to note that my client has had the GPS tether placed on him, and he does have no objection to an alcohol monitoring device of any kind being added as a condition of bond. Further, if the court would also like any sort of drug or alcohol testing apart from a scram or sober-link tether, my client would also be willing to do that as well. To my understanding, since the time of his arraignment and now, again, only being a couple of days, nothing has changed, and I do not believe there is any sort of bond violation or contact the complaining witness alleged since his arraignment or, quite frankly, his arrest. My client does have an address in Northville where he stays with his 2 children that are not with the complaining witness. His kids are ages 10 and 14. I do have this address in Northville. The complaining witness does not live there. He completely understands the conditions of bond of no contact and no go-to. It is my understanding the complaining witness lives in South Lyon, far away from this Northville address, and that she resides with their 2-year-old.
Define far away.
Not within the same block or neighborhood or anything like that. Obviously, it's within the same state. Northville being far or a distance from South Lyon. It is further my understanding.
They're actually relatively close at points.
I'm not gonna go anywhere near.
Well, I'm just trying to figure out the distance between the two because,
It's like probably 10 miles.
yeah, relatively close. All right, go ahead.
Oh, so 10 miles or a completely different city away from where he would live. He does not live with the complaining witness. We do acknowledge they do have the 2-year-old child in common. It is my client's understanding that that 2-year-old child is now staying with the complaining witness at that South Lyon address with the complaining witness and her mother. He completely understands the need for no contact order. He states to me he's willing to do anything in order to stay out of custody. He does have full-time work at a construction company. I won't put the name of the company on the record, but he does do that in home remodeling, and he's been there about 6 or 7 years. To my understanding, this is his only pending criminal matter of any kind. Further to my understanding, at the time of this alleged offense, he was not on probation, parole, or bond in any other matter. To my understanding, his most recent prior conviction was a 2013 drinking driving conviction, so about 12 or 13 years ago at this point. Ms. Anderson from our office has been able to speak to my client's sister directly and was able to confirm where the kids are currently.
Now, this is a pivotal moment. The breath test reportedly came back at a .189, more than twice the legal driving limit in most states. And suddenly, that prior alcohol history becomes much more relevant. Notice how the defense pivots strategically. No objection to a scram tether, no objection to alcohol monitoring, no objection to testing. That's not accidental. They're signaling cooperation. They're trying to reassure the judge. You can control the risk without raising the bond. But here's the tension. Prior operating while intoxicated convictions, including one as recent as 2017, complicate that argument. Judges often weigh recency heavily. So the real question becomes, is this someone who learned from past mistakes or someone repeating a dangerous pattern?
Staying with their mother. Again, his GPS tether is
his kids.
Yes, his 2 children are currently staying with their mother, who is not the complaining witness. Again, he is not asking for any contact at this time. I won't comment on the actual allegations of the case itself, given I haven't even had the opportunity to review a police report or anything of that nature. But I will note that my client does deny these accusations and states that there is a lot going on. He does understand his bond conditions, especially the no contact, no go-to order, and he understands that, quite frankly, if there's any sort of whiff of bond violation or contact or text or anything, he would be right back in custody, and he does not want to do that. And this is his only pending matter, Your Honor. So we would ask that bond remains the same. Of course, he has no objection to an added condition of the scram tether or sober link.
And there it is. The judge makes a decisive move. Alcohol monitoring is now mandatory through a scram tether, and the bond jumps from a personal recognizance release to a $15,000 cash surety. That's a significant shift. The court explicitly calls the original PR bond an abuse of discretion, pointing to the severity of the allegations and the defendant's alcohol-related history. Importantly, this is not a finding of guilt. It's a determination of risk management while the case proceeds. The judge is balancing presumption of innocence against community safety and alleged victim protection. So what do you think? Was this a necessary correction or too harsh before trial? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.